Okay, good morning.
Good morning.
Okay, we're here on the case of Peck versus Rosado, 20-2099. Each will have 20 minutes aside for oral argument. Appellant is entitled to divide this time between initial argument and rebuttal argument. So if appellant's counsel wants to let me know how much time they wish to reserve for rebuttal, I'll try to help them in that regard, but there's also a clock on the screen. This case is being live streamed so the members of the public can watch this oral argument. I'm joined today by Judges Cohen and Nardella. So with that, if the appellant wishes to proceed.
Good morning, Your Honors. May it please the court, my name is Poppy De Cunto and I represent the appellant Jessica Peck. I'd like to reserve 5 minutes for rebuttal.
Okay.
Your Honors, this is an appeal from an order of contempt after the trial court improperly found the appellant violated the terms of a temporary injunction by driving in front of the appellee's house, and the entry of an amended permanent injunction entered as a sanction for that contempt. The trial court's orders were in error for several reasons. First, the amended permanent injunction was entered without due process and as a contempt sanction, which is impermissible. Second, there was no substantial.
Counsel, we've read your brief. We know the issues that you're being raised. So outside of what you've told us in your brief, what would you like to add or expand upon?
Your Honor, I think that the argument I'd like to focus on is whether or not the order of contempt must be reversed as the modified temporary injunction was ambiguous, since that was the only argument that was actually addressed by appellee in their brief.
Okay.
And specifically, Your Honors, as cited in the brief and as Your Honors know from Robinson versus Robinson, a person cannot be held in contempt for violating court's order if the order is not sufficiently explicit or precise to put the party on notice of exactly what it must do. Here, the temporary injunction specifically allowed the appellant to reside in her house, but gave no directions whatsoever as to how she was to get to or from her house.
Let's assume, for the sake of discussion, that we agree that it was ambiguous under the circumstances where two people who are former girlfriends or friends are living on the same street. Would the what do we do with it from there? Do we remand it, or what do you do? What's your relief? What relief are you seeking?
Yes, Your Honor. I think as to the order of contempt, you overturn that order specifically because the temporary injunction is too ambiguous to enforce. As to the amended permanent injunction, I think that that should also be reversed. And under the circumstances, I don't think it needs to be remanded because Your Honors have all of the record evidence in front of it as to what appellee believed justified the imposition of an injunction in the first place. And the evidence.
So that's a little, you understand, that's a little different issue than the vagueness of the injunction. You're arguing that the injunction should never have been granted, that there was insufficient basis for the issuance of the injunction initially, correct?
Yes, Your Honor. In addition,
Well, talk about that.
Your Honor, the only record evidence that was submitted at the September 3rd hearing was evidence specifically as to Ms. Peck's allegedly driving in front of the home. In addition, the affidavits.
Is there evidence that she left things at the doorstep and some other things that occurred?
That evidence was in the affidavit submitted in order to obtain the temporary injunction in the first place. There was evidence that she left some items for COVID relief, toilet paper, things like that at the appellee's home, that they walked their dogs at the same time. And there was evidence that she submitted or sent some letters to appellee. When you review those letters, which were attached to the application for the temporary injunction, they're not threatening. There's no violence. There's nothing that meets the standard of law to justify finding that there was any evidence that she was a person who was willfully, maliciously, and repeatedly following or harassing another person.
If I call an ex-girlfriend, 10 times a day, 20 times a day for a week, even if I'm not threatening, can that form the basis of an injunction?
I don't think so, Your Honor. Under this court's ruling of Lazarenko versus Gerhardt, there was the appellant there sent multiple emails, sent a card and a package on Valentine's Day, an email on Easter, and was wishing the person a happy Easter. There was one email that the person in that situation sent at the very end of that long train that had some kind of threatening tone. And even under those
What if I call 100 times a day?
I don't think that that would actually reach the level of
Harassment? You don't think that could constitute harassment?
Well, I think that harassing is to engage in the course of conduct directed at a specific person, which causes a reasonable person to be substantially emotionally distressed and serves no legitimate purpose. So I think under those circumstances, the court would have to investigate what was the purpose of these 100 phone calls. To the extent that they serve no legitimate purpose and were only to continuously harass and disrupt that person's life, then I think, yes, at a certain level, that might reach the definition of harassment. But we didn't get anywhere near that in this situation.
Well, let me ask you about your proposed outcome of the case, that it not be remanded. Now, I think in your brief, you said that the trial judge convened the hearing by saying, we're here in session for our order to show cause. So in that regard, the only evidence that would be relevant would be evidence as to whether there's a violation of the temporary injunction or not. Would you agree with that?
Yes, Your Honor. I think that was the only evidence that the court should have been considering. However,
Right. So given that, would it be appropriate for us to tell, Ms. Rosado, you don't get a chance to put on evidence on whether an injunction, permanent injunction, should be granted in the first place because you didn't put on that evidence in a situation where the judge had said we're here on order to show cause, in fact, where that's the only thing that had been noticed?
it would be appropriate under these circumstances because counsel for appellee was the one who specifically requested the entry of a permanent injunction at the conclusion of that hearing.
Which you claim is error. And you claim that is error.
Correct. I do claim that that is error and violated due process, but because counsel for appellee was seeking that and had the opportunity already to introduce whatever evidence that they wanted to justify the imposition of a permanent injunction, then I don't think they get a second chance at the apple because they invited error.
Were they seeking that as a sanction for the violation of the temporary injunction? Or were they seeking that they were otherwise entitled to it? Or does the record reflect that?
The record does not reflect that. There's a single statement at the end of counsel for appellee's argument after presenting the evidence and when he's making his final argument that then says, and therefore we would also ask for the imposition of a permanent injunction. So I'm not sure what was in the intent of appellee counsel's mind, but I believe because they were there under the belief that they were entitled to a permanent injunction, they already had the opportunity to put on all of the evidence in front of the court, and in fact did not submit those affidavits. So I don't think that was in front of the court on that day and was never entered into actual evidence, although it is part of this court's record. And therefore I think it would be also a waste of judicial economy since the court can already examine all of the evidence that appellee has to justify whether or not she's entitled to an injunction. And as a matter of law, the allegations don't rise to that level. Therefore, we believe that it would be improper for this court to remand it for further proceedings since appellee's counsel is the one who invited the error in the first place to then get a chance to seek a permanent injunction at a later time. So as to the specific remedy, again, the order of contempt must be reversed since it was too ambiguous as to what appellee was entitled to do. And because there's no substantial competent evidence to justify the entry of any kind of injunction, this case should just simply be reversed.
Appellee was in the process of relocating at the time this was occurring. I assume that's occurred.
That's not part of the record, Your Honor, but it has occurred is my understanding, yes.
All right.
At this time, if there's no further questions, I'll reserve for rebuttal.
All right, thank you. All right, Mr. White, rebuttal.
Yes, may it please the court, William White for the appellee, Ms. Rosado. In terms, Your Honors, of the violation of ambiguity in the temporary injunction violation and the
Well, let's start with the due process.
Certainly. Oh, well, Your Honor, the fact that there was a hearing set for the final injunction, the individual appellant was on notice at that time that she was subject to a permanent injunction.
Really? How?
Excuse me, Your Honor.
How was she on notice of that? You know, you set a hearing on contempt. How does that put them on notice that when you walk into that hearing, you're going to leave the hearing with a permanent injunction being issued against you?
Certainly, Your Honor, and perhaps it does not, but she was well aware that she was under and did have a scheduled hearing. I think 1 month out, it was late October, which in judicial efficiency, I guess the trial court just removed that and granted the permanent injunction at that time. And we
all right. So, Mr. White, why
request,
don't you get what? I noticed in your brief, even though your table of authorities said that you cited 2 cases, in fairness, you actually cited 3, none of which were terribly helpful. So why don't you give me one case that you can cite for the proposition that when you notice a hearing for contempt, that you can walk out of that hearing with a final judgment against you? Give me one case that stands for that proposition.
Yes, Your Honor. With respect, that I cannot do, and that is why we request that the remedy would be that we get our day in court and properly notice on the final injunction and properly notice the appellant.
It just appears to me you walked this trial judge right into reversible error.
Mr. White, I want to talk to you about the grounds
Certainly.
for which you got the injunction, the injunction for stalking. What evidence in this record? What's your best evidence in this record that anything was done with malice? Anything was malicious as required by the statute?
Certainly. And the issue, I believe, is that the appellee on multiple occasions had requested that the person she was in a former relationship with stop contacting her, leave her alone, and the individual continued to pursue and deliver packages, come to her home, leave things on her doorstep on multiple occasions. And any reasonable person would begin to feel an imminent threat from that after requesting multiple times that it not happen. And it is malicious to continue to harass someone when they are being emotionally disturbed, nervous, and at any time being nervous that somebody may show up at that door that they don't want to be there. And the fact that she could.
Is there any particular piece of evidence in our record that you could point to? Was it, the dropping off of COVID supplies, the masks, the toilet paper? Was there a particular letter?
It was, and the tone of the letters and the deep, prolonged, emotional letters that were left, along with the relief packages, reaching out, consistently admitting in those letters that she understood she did not want to talk with her and had asked her to leave her alone, and yet she chose to continue to bring the packages and the letters after appellant had admitted in her letters that she was making her former friend uncomfortable by doing so.
Let me ask you, on the temporary injunction itself, would you agree that if you follow the language of the injunction, it meant that the respondent could stay in her home, but couldn't exit the home because otherwise she'd be violating the 500-foot restriction?
Well, I think that if I were to instruct someone to stay 10 feet away from a location and they resided 8 feet away from the location, I would certainly think a reasonable person would realize going to 7 feet would be a violation. It wouldn't be that, and no reasonable person would believe, and the trial court did find that the testimony was not credible, that she did not understand the limits of the injunction. But I don't believe it was ambiguous to a reasonable person to think that if 2 numbers are mismatched, that means I get to take even less than the lowest distance.
Well, under the express language of the injunction, did she violate the injunction if she stepped out of her house?
Yes, she would have.
All right. And can a trial judge do that on a, injunction for protection like this?
Well, I think it
Sounds kind of like a house arrest situation. Either that or you got to move out of your house.
certainly, but I would hate to see someone given a benefit as a result of an accommodation to allow them to live in their home.
Do you think a trial judge has the authority to effectively remove someone from their home?
I do not.
No, that's not giving them the benefit
They
of the
have the
doubt.
right-
Then you're letting them exercise a right that they otherwise have.
Well, she had the right to be in her home, but she did not have the right
To leave it.
to be within 100 feet of the appellee's vehicle. So the 500 feet, where she was within the 500 feet, the injunction was still in place, and on multiple occasions, she drove by while the appellee and the appellee's vehicle were in the driveway under which the injunction prevented her from being within 100 feet of that vehicle. That was not ambiguous in any way.
Let me ask you, the fact that her attorney told her to drive the other way, does that become part of the injunction?
I would hope to a reasonable person it would be, but I understand it's not in the document.
All right, any further questions? Anything else, Mr. White?
No, at this time, I would ask that the remedy be here is that the order for contempt be upheld. There was an admission of a violation, regardless of the 500 feet and the ambiguity of that. She was still to be not to go within 100 feet of the vehicle, which she admitted she violated on multiple occasions.
Well, let me ask you this. I believe she testified there was construction the other way at times. Was there anything that refuted that?
No, and she presented no evidence, and there's no evidence in the record that that is true. There was,
Well, she
evidence was
testified to that,
requested.
right? She testified to that, right?
She testified to that.
That's
and
why my question was there any testimony or evidence to refute that?
No, other than the judge did not find her credible.
And
Okay.
Mr. White, is there any evidence to suggest that she drove by multiple times? Sometimes it was seen to be the respondent, but sometimes it was possibly someone unknown, and she suggested it could be other people that had use of her vehicle. When you make the argument that she came within 100 feet of the petitioner's vehicle, is there any evidence in the record that the respondent was the one driving the vehicle when her vehicle was spotted as 100 feet within the petitioner's vehicle?
In the record, she did admit that she did as well, that other people could have driven it, but she made no claim that she had driven it, that she never drove the vehicle.
Well, if the only evidence was that construction prevented her from leaving her house going the other way, would that be a willful violation of an injunction? You're saying it would be improper to enjoin her to leave her house. If she could not leave Route 1, but she could go to Route 2, and Route 2 took her by your client's house, is that a willful violation of the injunction? Or are you saying, well, she can leave her house as long as she doesn't go, can't leave with her car though?
No, she actually, initially upon the filing of the temporary petition for injunction for stalking, she contacted her attorney. It's in the record, and they immediately filed for a modification so that she could reside in her home. And that was done very quickly after the service of the injunction. Her solution would have been, if the construction prevented her from leaving by an alternate route, why was not that modification of the injunction sought in that case?
The judge basically denied her relief. The judge said, you can live in your house, but you still can't go within 500 feet of the respondent's residence, which meant she was stuck in her house again, which I think we've already kind of agreed was be an invalid provision. I mean, if the judge says you can't, in essence, you can't leave your house because you're within 500 feet, what does it matter which way she goes under the judge's order?
Well, they specifically asked in the modification of the temporary for permission to drive by the house, and that was denied.
Exactly. So it leaves her again with the situation that she cannot leave her house if she wants to follow the express language of the injunction. So what does it matter which way she goes?
I would argue a reasonable person in court, the subject came up and her attorney instructed her to drive the other way.
But in determining the validity of the injunction, do we say, well, she still would have to violate it, but she could have violated a little less? Or do we determine that the injunction itself is invalid, in which case the order of contempt is invalid?
Well, I've got to stick back to reasonableness, Your Honor, and any reasonable person would interpret, after being instructed by their attorney to drive the other way in open court, and knowing that they were allowed to reside in their house by the modification of the original temporary injunction, that they would follow the instructions of their attorney. Technically, perhaps the moment she stepped outside that door, she was potentially in contempt. Because of that, it wasn't so clear, but I would hope that there would be some reasonableness standard as to how someone can behave when a court has ordered them to not continue to harass or stalk another human being.
Mr. White, I'm sure you looked over the initial brief that cited cases that stand for the proposition that you can't go in for a contempt action and walk out with a final judgment. You have no cases that you cite contrary for a contrary proposition, and yet you're asking us to affirm. I don't understand how that can be.
Well, I'm asking you to affirm the contempt, and if required, remand for to have a hearing on the actual final injunction.
All right.
All right, any other questions? All right, anything further, Mr. White?
I have nothing further, Your Honor.
All right, thank you. Any rebuttal?
Very briefly, Your Honors. As to the 100-foot restriction, the evidence at the hearing on the order of contempt was there's an allegation that the appellant drove in front of Appellee's house 8 times. The evidence was that at no time did appellant know that the appellee was home, as the car was parked in the garage. The third-party witness that testified admitted that there would be no way for the appellee to know that she was home, that there was construction on 2 separate occasions that would have forced her to drive that way. And as the court has pointed out, that there were other individuals who drove her car from time to time. So there was no evidence about how many times Ms. Peck actually drove in front of Ms. Rosado's house, knowing that Ms. Rosado was there. The 100-foot restriction, I believe, is a restriction that says you will not knowingly come within 100 feet of the party's car. So I don't believe there's any evidence in the record to show that she knowingly violated the 100-foot restriction. And as the court has already pointed out, she was always in violation of the 500-foot restriction, regardless of what her attorney said. Her attorney's comments are not in the order, and the onus is on the court to make sure that its order is properly precise enough to instruct the individual as to what they can or cannot do. The fact that the attorney needed to make some kind of clarifying statements further demonstrates how ambiguous that order was. With that, Your Honor, we would ask that you would reverse the order of contempt and vacate the order of permanent injunction and not remand for further proceedings.
All right, well, thank you both. And